My name is Jody Souza. I'm the Education and Events Manager at SCORE, and we are joined today by Anne Michelle Francis, who is the Senior Paralegal at Eviction Service Center. We have Tim Bobian, who is the SCORE Government Affairs Manager, and Jordan Nunez, who I think this might be his Zoom debut as our Government Affairs Coordinator. So I'm going to turn it over to Anne Michelle, who's going to talk to you today about the eviction moratorium and what it means. If you have any questions, please put them in the chat box and Q&A. We're going to do all those questions at the end. So your question that you may put in 10 minutes into this might get answered. So just hang tight and we'll get to everything. So Anne Michelle, I'm going to kick it over to you.
Hi everyone, I'm Anne Michelle. It's awesome to see you and see how many people are out there and interested in the eviction moratorium talk today. I will share my screen real quick and get my presentation up for you. And here we go. So let me go back. My name is Anne Michelle. I'm a senior paralegal at the Eviction Service Center, and I work under attorney Dan Paris. He is also my father. We've worked together for 15 years, and I have been managing the office and managing evictions for that long as well. So our office is based in Santa Clara County on Stevens Creek Boulevard. Our specialty is Santa Clara County, although we have become very familiar with everything happening throughout California. It is all confusing, and I am hoping to bring some clarity to that for you today. So let's get started here. So that's who we are. And today my presentation is what the eviction moratorium means to landlords. So this is a guide for property managers, for realtors who dabble in property management, and for landlords, so self-managing landlords. I'm gonna go through a quick recap of things that have changed in the law over the last month and a half or so to bring you up to where we are today. This is a very quick, not comprehensive recap, but we're starting with March 4th, which is when California declared the state of emergency. Then on March 16th, the state of California's governor issued an executive order placing a moratorium on evictions and allowing tenants to defer rent for both commercial and residential properties through May 31st. On March 18th, San Jose enacted their own eviction moratorium, which was more specific than the state's. On March 24th, Santa Clara County enacted their own eviction moratorium, which again differed than San Jose's and differed than the state of California's. On March 27th, Mountain View enacted their own. The state of California issued another executive order, and the stimulus bill was also signed. So these things were game changers significantly because the stimulus bill prevented evictions for 120 days after the state of emergency. 120 days, and that significantly changes the eviction moratorium because it didn't have any requirements or restrictions. It was just a general hold on evictions. On April 7th, the Judicial Council of California made an even bigger move and brought it back close to home and said that there are no evictions for 90 days after the state of emergency ends. So what does that mean for a landlord? This is a general summary here. This applies to commercial and residential for the state of California and for Santa Clara County. The city of San Jose is specifically only states residential, so that means you would default to Santa Clara counties for anything commercial. What the local moratoriums do is they give you between 7 and 15 days for the tenant to prove they've been impacted by COVID-19. So if rents due the first of the month, then tenants have up to 7 days to be able to prove to you how they were impacted. Certain ordinances have given a little bit more time. So the eviction moratorium in Mountain View, I believe, gives 14 days. So each city has created, many cities have created their own, but this is just a general frame of reference. Of course, before you actually were to start an eviction, we would take a look at it and make sure that everything's been served correctly. But in the interim, this just gives you an idea that tenants have between 7 and 15 days after rent is due to prove that they have been impacted by COVID-19. The city, the county, and the state are all very clear in that a tenant needs to be impacted by COVID-19 in order to qualify for any deferral of rent. For the city, state, and county, rent is also to be deferred through May 31st. To be very clear, this does not mean that it is waived. It does not mean the tenant doesn't owe April or May rent. It means that they can defer it to a later date. It is not specific for certain cities how long the tenant has to repay. However, Santa Clara County is specific in that they've said they have 120 days to repay after the state of emergency is over. Because right now all of the moratoriums go through May 31st, we are assuming that that 120-day time period would start June 1st. But we do not have any confirmation now because anything is open for extension. But that is the date that we are referencing now, is when the moratoriums end on May 31st. To be clear, San Jose does not have a specified amount of time for repayment, and neither does the state of California. To give you our own office's feedback, it is probably unrealistic for a tenant to be able to come up with 2 full months of rent if they were in fact impacted by COVID-19 in only 4 months. And you may want to give them longer payment plans, more like 10 months or 12 months, in order to get them to repay. We've also found that you will have better chance of the tenant repaying you if you collect something for the months of April and May. So if you can negotiate something with them, such as $500 a month or $1,000 a month, or some sort of proration, then there's a better chance that they won't just skip out on you on the rent, and that they'll pay and hopefully stay throughout that period of time, and also maintain their obligation for payment. There are no late fees or interest that can be charged during this deferral payment or the payment repayment program. So you can't charge any late fees on that. Now, the more questionable part is that there are no evictions until September. You may hear several dates, such as May 31st is when the last day the courts are closed, and they open again on June 1st. So it's a little bit misleading because you would think that you can file your evictions on June 1st then. However, the Judicial Council has a moratorium for 90 days after the state of emergency ends, which means that no summons, and you need a summons in order to file an eviction, no summons can be filed until, no summons will be filed until 90 days after the moratorium ends. So after the state of emergency ends. So that's where you start getting into some confusing dates. June 1, the courts may be open, but that doesn't necessarily mean that you can file evictions on that day. Where we are right now is that we are waiting because we believe that there will be additional rules once the moratoriums once we get closer to the moratorium's date lifting, and as courts start returning back to the office and having more rules for us. So a lot of this is just on hold. Another note is that evictions will probably take a long time when we can do them again. Right now, evictions take about 4 to 6 weeks, depending on if a tenant files an answer. We are anticipating evictions taking 6, maybe even 12 months when we do come back into session. We have no idea, but we do know that the courts will have been closed for 2.5 months by the time they do open again. And so being that they've been closed for 2.5 months, there are a lot of evictions that are normally filed every month. None of those have been able to be filed. So we will have evictions that need to be filed. We don't know if we can file them in June or if we need to wait until September. And so we're looking at a significant period of time just because of the backlog and the lack of staff to process them. So what does it mean to have 0 evictions? I think this is the most challenging concept to understand based on the questions that I receive on a regular basis. No evictions means that these things can continue. So no evictions means that a breach of contract that you normally can enforce by means of an eviction can't happen right now. Examples include non-payment of rent. If your tenant didn't pay you rent for January, February, and March, there's nothing you can do about that right now. Another example is utilities. It doesn't matter if the utilities were due for April or if they were due for January. There's nothing you can do about it right now. For breach of contracts, such as additional occupants, unauthorized pets, bad behavior, or even termination of tenancies, such as another co-tenant in the property, or sorry, we'll go to termination of tenancy in a second, but breach of contract like occupants, security deposit, pets, bad behavior, any of those are not reasons that you can start an eviction anymore. So right now you just have to deal with it. If you have unauthorized occupants, you should be serving warning notices and letting them know that's not okay. But there's no method of enforcement right now while there are no evictions, and this is not just because the courts are closed. Further, there are no terminations of tenancy. You cannot give notices to terminate tenancy right now. That means even if you have a co-tenant in your house, it means if you are a realtor and a property, you've closed on a property and you need to get the former owner out, or you need to get a tenant out, you cannot issue termination notices. And it's the same thing if you are a property manager. You can't issue a 30 or 60 or 90-day notice right now. This also applies to short-term rentals. So in the short-term rental aspect, it's if you have an apartment complex or a home or a condo and your tenant is Airbnb or VRBO or using the property as a short-term rental and that's not authorized, you can't do anything about that either right now. So what can we do right now? We cannot do very much right now. The most proactive steps that you can take are to serve a 3-day notice. Our office has a specific 3-day notice that requests the tenant to also prove that they've been impacted. What we don't know about the notices that we're serving is whether or not they will be good come June 1st when the courts open again. So right now, our office is no longer preparing or serving notices because we are not an essential service. However, property management is an essential service, so you can prepare and serve your own 3-day notices. However, we are not sure if that 3-day notice will be good come when it's time for the courts to open again. So in the meantime, we suggest serving a 3-day to get your tenants to start talking to you. If your tenants are ignoring you and haven't talked to you, then maybe start with a 3-day and say, please let me know and communicate with me if you've been impacted by COVID-19 so that you can start getting the ball rolling and you can start opening those lines of communication in order to find out if they have been impacted so that you can break down if they do qualify for deferred payment or not. We suggest you negotiating. If your tenant has or hasn't been impacted, right now is a time where you can't enforce an eviction, so it's very important to just start negotiating and talking to your tenant. Find out, can they pay anything? If they can't pay anything, then maybe you work it out once they found a job again. If they can pay something, then take that. And then another option is to enter into a deferral agreement. So you can only enter into a deferral agreement if the tenant is already negotiating with you. So if you've served them a 3-day, they've come back and said, yes, I've been impacted, can we create an agreement? Then you want to come up with your deferral agreement that shows that they will repay you a certain amount each month. Now, since I last did this presentation, things have changed a little bit because we're still going into shelter in place. When all of these eviction moratoriums first came out, we thought maybe they were 2 or 3 weeks. We didn't realize they would be over 2 months of time. And that's the challenge we have now is it possible for a tenant to be able to make enough money to come up with these repayment plans, even if they enter into a deferral agreement, if their jobs still are not available and they still don't have that income? That's the big challenge we have right now. And you must look at each one on a case-by-case basis. What if they ignore you? So you've served a 3-day notice, requesting feedback, requesting a conversation, requesting proof that they've been impacted, but they end up ignoring you. What if they don't pay you, they ignore you, they don't want to create an agreement? So instead they've locked themselves in the house, they're not talking to you, they ignore your calls. Normally this is when someone calls me and wants to start an eviction because they're unable to work with their tenants anymore. In this situation, you can't start an eviction, so all you can do is wait. This is probably the time that if it's a financial burden for you, then you need to start contacting your mortgage company. Maybe you need to refinance. Maybe you need to add a HELOC. You need to start protecting yourself in the event that the tenants don't pay, in the event they don't pay again, in the event they don't move out, and in the event that you need to start an eviction, because you may not be able to start an eviction until September 1st if they were impacted by COVID-19, and that eviction may take a long time. So you need to prepare for that. So what can you do? There's not a whole lot that you can do. You're very, very restricted in your options by not having an eviction. However, there are some options, and I'm going to start with the least favorite options that we have. You can do an eviction if a tenant is a threat to the health and safety of the public. So some examples here are an apartment complex where there's an occupant who is now letting homeless people move into his unit. They're infiltrating throughout the common areas. They are making it toxic. They have people who aren't adhering to social distancing. That's possible that could be a threat to the health and safety of the public. Now, this is not something that most eviction offices have ever done before. We've never processed an eviction on this before during an eviction moratorium. This is an unprecedented time for us as well. So this type of eviction is very extreme, and we don't take this lightly. So it would be considered on a case-by-case basis in order to do that, and it would need to be extreme, and there would need to be a lot of proof. So that's why it's important right now to make sure you are serving warning notices if your tenants are in breach, because if you need to file an eviction for one of these reasons, you want to be able to have that proof. Another reason is a forced eviction for trespassing, and that's more specific, and again, just a case-by-case basis. I've never had to do that one either. So these are the least favored options, mainly because they will be case-by-case and they will be very expensive to process. These are not your cookie-cutter evictions. These are not straightforward evictions. They're going to be working closely with our staff to be able to do them. So these are worst-case scenario. Your next best option. To be honest, what I have found works the best right now is cash for keys. As realtors, you should all have a cash for keys agreement. If you don't, or you want one that's been drafted by our attorney, if you have watched this presentation, then you can have a free agreement if you email me, and I will talk to you about any other documents that need to be attached to your cash for keys agreement, because it's very important that you don't waive any rights that your tenant may have under a City of San Jose or tenant protection ordinance or apartment rent ordinance or any other eviction moratoriums. So your cash for keys agreement may be good, but you may want to use ours instead, because it does take those other issues into consideration. So cash for keys, negotiating with your tenant. Most tenants who aren't paying and who are hiding are doing it because they've lost their job and they just don't have the income. So if they don't have the income and they're scared and they're just waiting for the sheriff to lock them out and they're hiding from anyone who may knock on the door, that may be your cash for keys person. And my next question I'm always asked is, how much do I offer them? Well, let's think about that. Think about what your monthly rent is. Think about how much an eviction costs. An eviction costs a couple $1,000s. And then think about how long you may be without rent if you have to go the eviction route, which may be a year from now. It's only April and we may not be able to start evictions until September. So if you're looking at a year without rent, maybe more than a month of rent is what you offer for cash for keys. So you need to be really strategic there in what you want to offer and what you think it would take for your tenant to be willing to relocate as a result of getting that cash. Another alternative we have in the office is called a landlord bundle of documents. So that's a 3-day notice I referred to earlier, and it also has an attachment with the request for proof of impact. I go through an interactive training and support session on this each day with anyone who has purchased those agreements from us and those 3-day notices, so that I can make sure you have the right forms and you're giving everything correctly to your tenant, so that if the tenant comes back to you and says, I want to create an agreement, then the deferral agreement is also part of this bundle. And so the deferral agreement is something that you fill out. If the tenant agrees to repaying you at $300 a month until paid in full, then we can demand that on a 3-day notice for non-payment of rent also, if they do not stick to that deferral agreement that they came up with. The accountability options that we have in the office are not something that will get your tenants out of the property, but they're something that will hold your tenants accountable, because often the threat of a bad credit score is all that it takes for the good tenant who's there. So your options there are small claims court. So for example, if your tenant did not prove that they were impacted by COVID-19 and they're just choosing not to pay April or May rent, you can file a small claims court action against them on June 1st, demanding the April and May rent. That's not going to evict them. It's not going to get them out of the house. However, it will get you a judgment against them that will impact their credit, and hopefully that would deter them from deferring the rent or not paying it at all. There's also a civil lawsuit that's possible. That's what you would do for any amount of rent that's more than $10,000 that's due. That's a longer process, and the tenant has the option to file a counter lawsuit. However, that's another way of getting a tenant to be accountable when they owe the money and they have not been impacted by COVID-19. I do want to share a court update as of this morning. I was going live in my private Facebook group for landlords, and right after I got off of the live call, I checked my email, and a court case, an unlawful detainer, so an eviction case that I filed on March 16th, it was rejected. Now that's actually major news, and it's a little bit exciting. The reason is because I submitted it and I haven't heard anything, and today's April 23rd. So for over a month, I submitted it thinking it would at least be in queue. At the time, courts hadn't been closed yet, and I was just filing an eviction as usual. However, I thought it would be in queue so that when they open again on June 1st, they would file it. Instead, that's not what happened. What happened is they rejected it completely. Even though it was pre-COVID-19, even though it was before any eviction moratorium, they do not have it in queue. They are not just sitting on it. They sent it back and said, resubmit after June 1st. It's exciting in the sense that it means people in court are working. It means that they're back. It means that they're doing something, where for over a month, we've had nothing. We've had absolute silence. Yesterday, a court date was set in our office for a different type of case, a different kind of matter. And so again, courts are there, the clerks are there, and they're starting to file things. And so that is an exciting progression toward the June 1st date. And we're hoping that more rules will come out about what we can and can't file on June 1st. I'm now going to answer the top 5 questions that I get on a regular basis through our office, through the Eviction Center. So we only help landlords, and these are the questions that I get from the landlords. So it's the middle of the month and I haven't heard from my tenant. What do I do? So it's the middle of April, haven't heard from the tenant, they haven't paid rent, and often landlords get angry and say, well, why haven't they reached out to me? If they lost their job, they should be telling me because they owe me the rent. I shouldn't be following up with them. Well, we don't know anyone's situation right now. We've never had an eviction moratorium before. We've never been on lockdown and in shelter in place before. So this is new for everyone. Tenants don't know what to do. Owners don't know what to do. So act with compassion. And if you can't act with compassion, then hire someone who can. Because right now, everyone's in an extremely volatile state, whether you still have your job or whether you don't have your job. Everyone is confined to their home, and you don't know what kind of condition that puts them in. So be understanding and be sympathetic. You don't need to give away rent for free. You don't even need to reduce rent, but you just need to be open to understanding instead of accusing and saying, well, why haven't you done this? And if you don't feel that you can do that, then find someone who is and have that person be the intermediary between the two of you. But once you do that, and once you reach out, once you request for proof of impact, if the tenant proves that they were impacted, then create a deferral agreement. Let them know it'll be okay. And if that deferral agreement needs to change for May because their financial situation changed, then let them change that. But right now, they do need to prove it. They need to prove they've been impacted. The people that you haven't heard from and haven't proven it, we aren't exactly sure how we'll move forward with that in the future. We believe there will be more guidelines as we get closer to June 1st, but it's very, very clear that the city, the county, and the state all require proof that the tenant has been impacted by COVID-19 in order to have rent deferred. So you do want to find that proof sooner than later. However, if the tenant can't prove it to you, but still requests a deferral agreement, we suggest giving it to them only because of the amount of time it'll take to evict your tenant under these new guidelines and the way that the moratorium exists right now. Keep in mind, the moratorium may change. They may lift it. We may be able to do eviction sooner than later. It may not be a September 1st date. They are able to extend it, and they're also able to retract it. So we are just waiting, and you want to keep on listening for updates here. Second question is, my tenant lost his job and can't pay the rent. What do I do? So your tenant lost their job, and this is a really tricky situation because you don't want that tenant skipping out completely. Technically, they can have April rent for free. They can have May rent for free, and maybe they're just going to move out on May 31st and not pay you at all. So this is where your negotiation comes into play. If they've completely lost their rent and they lost their job and they can't pay the rent at all, maybe you do want to do a rent reduction. Maybe you want to negotiate rent for April and May. I don't want to say waive the rent because you're not required to do that at all. But if it's the difference between keeping them there and letting them stay for another year because they were good tenants, you know they will get their job back, and maybe working out a deferral agreement later on, that's something you can do too. You just want to be really careful you don't accidentally create a promissory note, and that's why a deferral agreement is so important. A promissory note is not something you can demand in a 3-day notice for non-payment of rent. So if you create a separate loan, essentially, a promissory note with a tenant, then that's a separate agreement, and then that doesn't apply to these deferrals and the repayment plans that are instituted by the county. So you want to be careful about any amounts that they are asking to defer and making sure it doesn't become a no. Third question is, my tenant won't pay, won't leave, and stopped returning my calls. What do I do? This is where you offer cash for keys. However, if they don't want cash for keys, then you're just stuck for now. That could all change. You want to stay in alignment with whatever eviction center that you use. You can get on anyone's email list so that you can get the latest updates. And so if you can start evictions earlier, then you can be in the know and know what's going on. You can also tune into my Facebook group where I continually update people and give them the most recent updates. However, if your tenant won't pay and won't leave, we've lost the right to enforce anything because we can't evict. So we have to just wait until we can evict again. There isn't another way right now. My tenant keeps breaking the rules, parking, drugs, quiet hours, etc. What do I do? Serve warning notices. You want to serve a warning notice. You don't want to do a 3-day for non-payment or a 3-day breach of contract. You want a warning notice. It can be a letter. There's nothing formal about it, but you would want the tenant's names on it. You'd want the property address and maybe start labeling the number of warnings that you're doing. This is warning number 1. You're in violation of the rental agreement because you've broken these rules. This is how you can correct it. Start your case, start showing the documentation trail so that you have that on your side. Because right now, without evictions, we can't enforce any breaking of the rules. My tenant was supposed to move out at the end of April, but now he can't. What do I do? This is a tricky one. I recommend getting your tenant to give you something in writing saying that they need another month, saying the day that they'll be out. If they end up doing that, saying I'll be out by May 31st and I understand that I will pay you the full month of May rent. But if they can't move out, so say that they are paying the rent, but they just can't move out because they don't want to go out and try and find a place. They are sticking strongly to shelter in place, or they have a compromised immune system. For whatever reason, they can't go out and look for something else. Then you want to get a notice from them saying how long they need in the property and the actual date that they will be out by. So if they need 1 more month, then have them put it in writing. I will be out by, and put the end date on it and make sure that every tenant in the property signs it. And that's something that you can start an eviction on. However, if your tenant didn't move out at the end of April, as long as you don't take any rent, as long as you don't take any rent at all, you can start the eviction based on your tenant not moving out at the end of April. The problem is how long the eviction will take, and we don't know. Further, my tenant will be protected by AB 1482, that's statewide just cause and statewide rent control. If he stays past April, how do I keep that from happening? Again, in this situation, you may just want to not take any more rent after the end of April and start the eviction when you can. If they don't want to get out, you want to make sure that you're not bypassing any rules and then possibly getting stuck by AB 1482 by keeping the tenant in there and continuing to take rent. I can assure you that if you take rent after April and the tenant was going to be out in April, if you take rent in May and you don't have any separate agreements there, then you are converting to month and then you are subject to AB 1482 if the tenant's been there more than a year and it meets all those other thresholds. So this is a situation where you would want to hire an attorney to make sure that you write the documents correctly. So that is my eviction moratorium presentation. I have a lot of time to answer questions. If you would like to join my private Facebook group, it's for landlords only, and this is the link where you can join it. And this is the contact info for our office if you would like to get in touch or have any further questions that I'm unable to answer today. So Jody, would you like me to answer the questions that I have here, or did you want to bring them in on the chat?
Yeah, why don't you answer the questions? So several of you sent in some questions before. So Ann Michelle and Tim are going to run, Ann Michelle's got them, she'll run through them and get those answered for you. And then Jordan will go through the Q&A box and the chat box. So any questions that you have, you can put those in and then we will get those answered, but we'll start with the free questions first.
Okay, so the first one I have is, what if the tenants are in your home you just closed escrow on? So in that situation, it's the same thing. The eviction moratorium applies. If you serve any termination notices, they will not be valid. Something I often see happen among realtors is that the selling realtor, the selling agent, issues a termination notice and then the property changes ownership. That previous notice is no longer valid. Once ownership changes, then you would need to serve a new notice anyway. So now assuming that the buyer has the property and they want to terminate tenancy on the tenants who are in the house, then they would normally issue a 30 or 60-day notice depending on how long they've been there. You can't do that right now. Right now, you can't, not only can you not start an eviction, you also can't serve any termination notices. Now, you could try, but we don't know if they'll be valid, and you may need to start over completely. This is where you would want to refer back to cash for keys. That may be your fastest way to get somebody out of the property, is just give them cash to go. Next question is, how do I force the issue of getting documentation that proves they're impacted by COVID-19? So like I said, the city, the county, and the state have all required the tenant to prove they've been impacted by COVID-19 to qualify for a deferred payment plan. However, how do you make a tenant? Well, one of the governor's most recent executive orders actually gives the tenants permission to not prove they've been impacted until the state of emergency ends. So June 1st is when they would actually have to show it to you. So even if they have not been impacted by COVID-19, they can technically withhold their rent for April and May and then not prove it until June 1st. On June 1st, if they're unable to prove that they've been impacted, then all of the rent is due June 1st. So that means April, May, and June rent would all be due on June 1st. So that is the challenge of somebody who's not proving it to you, is that they don't have to prove it right now, even though the city, county, and state says that they need to prove it within 7 days of rent being due. So that is a discrepancy that's a little bit challenging. You can't force someone to show it to you. However, if they're at some point, there needs to be a rule about them showing it and whether or not they did. So the best thing I can suggest in this situation is serving a 3-day notice with request for proof, saying, have you been impacted, and please prove it to me. And if they ignore you, then they ignore you. But hopefully that sparking that conversation is all that you need right now. Otherwise, you just need to wait until June 1st when we have more answers. Again,
I have a little bit of a follow-up question on that. Sorry. Do you recommend to people telling them that and saying, hey, if you don't prove it to me, even though you think you have until June 1st and you aren't impacted, you're going to owe me all 3 months of rent on June 1st? Or do you recommend that people just flat out tell them that, or just not say anything?
I'm cautious to recommend that, only because I think that applying it to that one situation, people may end up using it to other situations and using it as a threatening tactic. And you need to be really careful during an eviction moratorium. Again, we've never dealt with something like this before, and you don't want to turn what was, hey, these are the ramifications of what will happen if, into threats and blackmail. So you want to be really careful about that. So tread lightly and talk to an attorney if the negotiations are not going well. If you are unable to talk well with your tenant, then you probably want to bring an attorney in. You just want to make sure that you're not going to get in trouble, and that there aren't more tenant rights that come out as a result of the eviction moratorium, saying that people acted in a way they wouldn't have, but they felt threatened. So you want to be careful there. If a 1-year rent contract previously renewed is ending and rents are not paid, can we simply not renew? Yes, you cannot renew. The problem is that you can't evict. So if somebody does not want to leave and your lease ended, you can't evict them. So that means that you have to not take rent. Once you take rent, that converts into a month-to-month tenancy. So once you turn into a month-to-month tenancy, then that's your ongoing tenant, and then the lease doesn't matter anymore. The lease just rolls over into that. So it's a hard place to be in. Do you want to not take rent, or do you want to take rent and then you've written off the lease? So yes, you can just end it, but you can't evict right now. There's no way to enforce that end. Are we allowed to show properties? I'm not sure if this applies to houses for sale, or if this applies toward residential properties where you're looking for tenants. So I am going to say that for the residential side, right now there should be no contact. So what I've seen in the industry is people using lock boxes, using gloves and face masks, and putting lock boxes on the door, pulling up in the front and having the tenant meet them also, and then the tenant goes in, checks out the property, and then comes back out. So there are different standards that people are using. I have not seen anyone going into the property with a prospective tenant at this point, but that may be more of a question for a property manager to answer versus someone who specializes in the eviction process.
And Michelle, I can answer that and touch on it a little bit. Rental properties apply under the same light as for sale residential real estate transactions, which we did get included as an essential business. So as long as the rental unit is vacant, the prospective buyer becomes the prospective tenant and is allowed to enter into the property with the property manager or the owner of the property to do a walkthrough or a private showing. So you can actually go through and show the unit to the prospective tenant. It has to be just the property manager or the property owner and a maximum of up to 2 people who previously lived together to try to limit contact of people. And then in terms of getting a unit ready with a tenant that moved out and another one going in, you're allowed to go through and have the unit professionally cleaned for habitability and sanitation reasons. It's clearly listed in the shelter in place that you can do that, as it would be a health risk to not clean the unit. You can't do any sort of maintenance or upkeep. So if a tenant did leave a unit and you wanted to go in and rip the carpeting out and put in new carpeting or put in new appliances or paint the walls, that would not count as necessary for the habitability of a unit, but you can go in and clean it and do private showings.
Thank you, Tim. Can you evict a tenant for other violations like too many occupants and parking? Too many. No, you can't. And so that goes back to serve your warning notices to make sure that you just have a documentation and you want to add everything to your file so that you have a complete file on that tenant. So if and when you can evict, everything's ready for you. You don't want to have to start over in September if that's when we can start evictions again. You don't want to start over with all of your warning notices at that time, because the tenant protection ordinance in the city of San Jose requires warning notices first. So you wouldn't want to start over after the fact. Just start making it a part of your process now to serve warning notices. I have a tenant who did not pay rent starting January. Is it practical to evict now? This is something I see so often, and really you need to make it a part of your process as a property manager of when you expect rent. If you expect rent by the 5th of the month, you should be serving 3-day notices the 6th. And if your process is to start an eviction within a week or within 2 weeks or within 3 weeks, you need to start it, because now there's really nothing you can do. You don't have priority because your tenant didn't pay you since January. So if your tenant now was January, February, March, April, that particular eviction does not have priority over any other eviction that's going on. So you're just going to be out rent even longer. So it's really important to refine your management skills of your property if it's been that long since you've taken rent. Can I have a tenant sign a note in lieu of rent? I don't recommend that. I always recommend creating a deferral agreement so that you're not creating a note separately. Instead, you want the tenant to continue paying it and pay it as part of their monthly rent, just increase their monthly rent a little bit until it's paid in full. You can discount your rent if you'd like to. So for April and May, if you would like to discount your rent, you can. I know that is controversial among different property managers. Some say don't discount it. You can give them credits later on because you want them to keep on paying the full rent. Others say, well, I want to give a $100 discount, or I want to give them half off. I think that it just depends on your own management style. You just need to be you need to be consistent among all areas. So if you choose to give half off to one tenant, you should be giving half off to everyone. You can't pick and choose who you like better than the other. So you need to be consistent there. And so it may not be realistic to give those kind of discounts if consistency will be a problem. Also, when you do that, you want to make sure that you have it written down very clearly that it is not a new rent price. So you want to make sure you're not changing the rent as a result of a reduction. So if you reduce the rent by half and rent was $3,000 and now it's $1,500, you want to make sure the tenant doesn't believe that now it's $1,500 until the moratorium is over, or it's permanently $1,500. You want to make sure it's written down very, very clearly. A good deferral agreement will help you with that.
And can I touch on that a little bit as well? The city of San Jose is exploring the rent increase freeze, and we got the important clarification in there, just as Anne Michelle said. If you do decrease your rents for a couple of months, that wouldn't lock you in to that decreased amount for the rest of the eviction moratorium or for the rest of the rent increase freeze. It's protecting your base rent that's in the contract. It is still important to get that all in writing. but it will be clearly saying that in the ordinance that if you are working collaboratively with your tenant and decreasing rents for a couple of months, that you can bring it back up to that initial contract amount at any point. And then when rent increases are allowed again, that you can increase them by the maximum allotted amount based on that initial contract amount and not any decreased amount that you were using.
So I think I answered the question, can the eviction process get started and filed in court? So no, it can't. So there are two dates that you're going to hear over and over. So I'm going to clarify one more time. There's June 1st and there's September 1st. June 1st is the date that courts open again. We don't know what we can and can't file June 1st. There's an assumption that we should be able to file anything that's pre-COVID-19. So if I have a 3-day notice that was from early March that has nothing to do with COVID-19, I should be able to file that eviction June 1st. However, there are moratoriums that are stating that no summons will be issued, and without a summons, I can't file an eviction, and without getting that filing, I can't get it served. And there are numerous other delays down the line. We're not sure what those rules will be. So June 1st may be the date that we can start doing evictions on old evictions that should have been started before the moratorium, but September 1st could be the date also, and September 1st could change as well. So if that's confusing, it's because it is confusing, and we won't have more clarity until we get closer to June 1st. Can a leasee get early termination on commercial lease impacted by COVID-19? So this sounds like a question that's more driven from a tenant than a landlord. Although if a landlord is wondering if it's up to the landlord if they want to let a tenant get out of a lease early. They don't have to let anybody out of a lease early. They have the power to reduce the rent if they would like to, or to create a deferral and set up payment plans for it. But nothing in any of these moratoriums gives the tenant the right to get out of a lease early. It still says that financial obligation is there. It's just up to the landlord to decide how you want to pursue that. Are you going to write off April and May? Or are you going to make them repay it? Or maybe you have them repay it at a lower rate so that they will stay and not get out early? Because I don't anticipate that it will be easy to re-rent commercial space right now, especially retail and restaurants. So it may be better to reduce the rents for the April and May and just start collecting rent again starting in June. You just don't, you have to see how long the moratorium is going to go, and that's where you want to talk on a case-by-case basis to speak to each of your tenants and see how it impacts them and what they can and can't do. Are these moratoriums constitutional? Tim, I am going to let you take that one.
We've done a lot of work with city attorneys, outside legal counsel, trying to determine the legality of these moratoriums, and because they legally don't require that a tenant is not paying any of their rent, while realistically it may be difficult to collect all unpaid rent during this eviction moratorium, they legally are still required in the ordinance to pay it all back at some point. And for that reason, they are legal. They have tried to pass some other legislation, such as a rent suspension, that would eliminate a landlord's ability to collect rent at all. We feared that was a very clear constitutional violation of the takings clause of the Fifth Amendment, and it was. And so that was shot down. The state is proposing a bill that would force landlords to decrease rent collection by 25%. That will end up violating the same takings clause. So because they carefully worded the language, it is an eviction.
It looks like Tim froze there for a minute. So as soon as he unfreezes, we'll come back.
Can you hear me now?
Yes.
Okay. Did I cut off, or should I just repeat the entire part?
I'd say repeat.
Oh, okay. So we did a lot of work with city attorneys, county attorneys, legal counsel, trying to determine the legality of these eviction moratoriums, and what we've concluded, what we've heard, is that they are technically legal because they're not requiring the tenants don't have to pay any of their back rent. It legally does state that they have to pay it all back at some point, while realistically it may be difficult for a landlord to collect it all. There is nothing in specific legislation that says that they do not have to pay all unpaid rent. The city and the state tried to pass a rent suspension ordinance, which would have eliminated the landlord's ability to collect rent at all. That was very clearly a constitutional violation of the takings clause of the Fifth Amendment. He immediately defeated. The state is also trying to pass a bill that would force landlords to collect up to 25% of whatever current rent contracts are. That will also be a clear constitutional violation of the takings clause. But because it is an eviction moratorium and not a rent moratorium, and the language says that at some point back rent will have to be paid, it is legal and it does not violate the Constitution.
Okay, so Jody, I finished all of the questions that I have on my sheet. Did you want me to go over to the Q&A in the chat box here?
Yeah, Jordan is going to run through those. I don't know if you're going to start with the chat or with the Q&A first, but Jordan, go ahead and start with questions.
Okay.
And between Anne, Michelle, and Tim, you guys got it.
So what is needed by the renter to prove the impact of Corona?
That's a good question. It's going to be on a case-by-case basis. What one person may prove may be different than the next person. For example, if you have a household with 2 adults, but one of them qualified based on their income and the other was a part-time income, and the person with the part-time income is the one who lost their job, but their income didn't qualify them, then they shouldn't be impacted and they should still be able to pay their rent. So it's not specific, and they have put this obligation on the landlord. Things that you want are copies of pay stubs. You want a letter from the employer saying that they reduced their hours or they were furloughed. You can ask for proof of unemployment insurance and that they've applied for it. If they own a small business, you can ask for P&L, or you can ask for their internal system showing their sales that they receive, or you can ask for bank accounts to show over the last few months to show that they were impacted and there weren't any more deposits. So there is no rule of thumb. There are numerous things that you can do and that you can ask for. And on the forms through the City of San Jose, they're actually really good. So if you go to the City of San Jose's website, they have a form, and even if someone's not in the City of San Jose, it has a good standardized list of what would help prove that they've been impacted by COVID-19. So I recommend going there and checking out that site for that PDF.
And the city actually just opened it up a little bit further. There was concerns brought up by the council that undocumented individuals and workers and those that are self-employed couldn't really provide a pay stub or some of the things listed on there. So they opened it up as a way that maybe a self-written letter by an undocumented individual or a self-employed person could provide proof as well. So I think, unfortunately, we're going to see a very broad array of what constitutes a COVID-19, financial loss.
I think the main point is that you want people to show you something and you want them communicating with you. And honestly, if they're communicating with you, this goes back to the presentation, create an agreement, even if maybe they didn't lose the job, because an eviction is not going to help you right now. So getting something is better than nothing right now. Another form for undocumented income is text messages. That's another one I've heard. So if you have a cleaning service or a gardener, making sure that they keep track of text messages from people who've canceled on them saying, don't come out. That's also going to help their case from different phone numbers showing that they have been losing that income.
Another question here is, does the moratorium apply to single-family residences and duplexes?
The moratorium applies to everyone in the state of California, so residential and commercial, yes.
Can you send a 3-day notice via email?
That is not a valid form of service. Yes, you can send it that way, but that is not enforceable. There are 3 methods of service. One is personal serve. That means that you are taking the 3-day notice and handing it to the named occupant who lives in the property. Or there's substituted service, which is you're handing it to another adult in the property who's over the age of 18 and mailing a copy by regular mail. Or there's post and mail, where you post one on the door and mail a copy by regular mail. Never send it by certified mail, never send it by registered mail, and never hand it to a minor.
Can you sue the city or county for losses due to the executive orders?
Tim, do you want to take that?
Yeah, I would be happy to take that. You cannot, as we touched on earlier, that it's not illegal for the county or the city to implement something like this. This was one of our main arguments and defenses as to why the rent suspension was a terrible idea, is because it would have opened the city and the county up to hundreds of millions of dollars of liability. I would say that the best course of action would be, small claims lawsuit against the actual tenant for unpaid rent, but a lawsuit against the city would not be effective.
Is it the same process for a subleaser as it is for a regular tenant?
Yes, it is. The only difference between a sublessor, so I'm going to assume that we're talking about a sublessor, so it's somebody who's inside of a property with an owner. The only difference there is if the owner feels threatened or endangered, they can get a restraining order. So a restraining order is going to help them move out faster, but they would need to use those words, threatening and endangering. However, if the master lessor moves out and there's a sublessor in the property that has nothing to do with the master lessor, then no, the eviction process is the same. It would be the master lessor who's evicting the sublessee. It's only if they're co-tenants. So the main tenant is renting to someone else and they need to get them out due to a hostile situation.
If a tenant does not respond to a 3-day notice, how do you even negotiate?
You can't negotiate, and that would be cause for an eviction. Unfortunately, there's no way to do an eviction until we can evict again, and so you just wait. If they're not going to talk, you can't make them talk. This is when things are getting really hostile. Landlords are getting very angry with tenants. You try and bring in someone who can negotiate better than you if you're getting very angry about it. Otherwise, you just need to back off and wait, because you're unable to do an eviction right now.
What if there is a squatter beginning to reside in a property?
So a squatter, most people's definition of squatter is different than what it actually is. A squatter is actually a trespasser. However, often people refer to a squatter as someone that they gave a key to in a property and that person doesn't pay or has never paid or was exchanging, maybe doing services around the property in exchange for living there for free. So if you gave the key to somebody, that's not a squatter, that's not a trespasser. The only way you have a squatter or trespasser is if a trespasser broke into the property. Once you've given someone permission to live in the property, whether that's giving them a key or saying you could stay, then they have the right to be there and you have to get them out just like any other tenant. And so a trespasser, however, is someone who broke into the property. So if they've broken in, you should call the police. The challenge you have is if somebody once was a trespasser and has stayed there for months because maybe you didn't know and now can establish residency and has bills or mail coming to them, then they've become a tenant. So knowing what's going on in your property at all times is very important, but also addressing whether someone's a squatter or maybe they're actually a tenant that definition is, you have to be more clear on exactly what they are. Because if you gave them the key or gave them permission to be there, they are a tenant.
Is a deferral agreement enforceable, and is it different from a forbearance agreement?
So my understanding of a forbearance agreement is related to the mortgage. A deferral agreement is related to a tenant and a landlord, and the tenant repaying rent to the landlord, and that can be either commercial or residential. So they are different because the deferral agreement is deferring rent for a couple of months, where forbearance agreement has a different, it's tied to the note and tied to your mortgage.
And I can touch on that a little bit more. As Anne Michelle said, forbearances don't really apply to a rental agreement. They apply more to mortgages. The question asker may have been referring more to like a forgiveness agreement, because on the mortgage side, a deferral, a forbearance, and a forgiveness are all very different. Forgiveness is that the payment will never be owed. It's eliminated. It no longer exists. A deferral is that it would be tacked on to the end of the mortgage. So if you have a 90-day deferral, if the mortgage is set to expire June 2030, then the mortgage would now expire September 2030. And then the third one of forbearance is that when the forbearance period is over, the entirety of the unpaid mortgage is due immediately. So if you have a 90-day forbearance, depending on who the servicer is and if it's through a bank or if it's federally backed, it could possibly be all due at the end of those 90 days. But deferral versus forgiveness is what would be touched in a lease agreement.
It looks like we've wrapped up all the questions.
Okay, so
I think we have two.
Yeah.
I don't see any other questions in here. If anybody thinks of any after the fact, feel free to email them to me. I know this is very tricky, complex language. Your government affairs team is happy to try to help you as much as possible. And thank you for attending today.
thank you, everyone.
We just had one more question come in. If we want to ask
Oh,
it
here
real
we go.
quick about people that can't pay their mortgage or any of their what can they do, because that's what they were paying was with their rental income, and now they don't have that. Are banks doing anything? Tim, do you know anything about that one?
And that's a major fear, obviously, that a lot of our property owners are going through, is that, these rent payments, you're likely not going to receive them for several months after the eviction moratorium. And as I just said, with mortgage forbearance, in some cases, at the end of the 90 days, the entirety of the unpaid mortgage is due. I would recommend reaching out to your specific mortgage servicer, seeing what that individual bank is doing for you. If they're willing to work collaboratively, there's nothing really in the legislation that specifically protects our members from mortgage forbearance or unpaid mortgages, and this is one of the largest cause for concern surrounding this eviction moratorium.
Okay. And we did record this, so we are going to be sending out the recording. It will have Anne Michelle's contact information, her email, her Facebook group, how to get in contact with her. Also, it will also have the information for Tim. You can send him some information. And I do want to say that all of this information is Santa Clara County and San Jose specific. If you are doing business in any other county, in any other city, you need to go there very specifically and see, because some of them are doing different things. So you want to make sure you're following the rules where your property is. I saw a question come in about Alameda County, and I just want to make it clear that the information from Tim, Jordan, and Anne Michelle today was San Jose and Santa Clara County. And there were a few more questions that came in. So do you guys want to stay on and take those, or?
Yeah, you can answer a couple more.
A couple of them were asking for my email.
Yep.
Jody, if you could post it to all the attendees today, but it's very simple. It's just Tim, TIM at score.sccaor.com.
Okay. And somebody said that somebody didn't want to pay because they can't go to the bank. The bank is open. I will say that you can go into the bank. I went into the bank. There's a sanction in front of between you and the teller. So I will just say that the bank is open. So, okay. Well, I will wrap it up then. I want to say thank you to Anne Michelle and Tim and Jordan for all the great information. Again, this has been recorded, and we will be sending it out to everybody with their contact information, so you can send questions and get more answers. So thank you to everyone. I really appreciate it.